Good. Well, thank you very much. Thank you very much, Marinez, and good afternoon, everybody. Welcome to today's webinar, episode 5 of Association Continuity in a COVID World. My name is Craig Vaughn. I'm the president of Castle. For those of you who don't know Castle, we specialize in the management of apartments, condominiums, and HOAs in Florida. We partner with approximately 300 associations through 7 offices in the state with 1,750 teammates. I'll be acting as your moderator this afternoon again and playing the role of a board member. Firstly, welcome back. For those of you who are rejoining us from previous episodes, we welcome you back. And for those of you who are new, thank you very much for joining us this afternoon. Thank you again for your leadership and your thirst for information. We received over 700 registrations for the webinar this afternoon and approximately 400 questions. Great questions, in fact. I've incorporated as many of those questions into our webinar this afternoon as I could. Of course, you are welcome to continue to chat questions in through a Q&A feature that was displayed, and I'll attempt to work those into the discussion as well. We introduced polling last week, which is very exciting, and we're gonna do some more polling again based on the feedback we received that it was a popular feature. So we've stepped up our game, and we'll do some more polling this afternoon. In fact, we'll get started very quickly. I'd like to start with our first question, Ness, which is where to find out, to get a feel for where everybody is coming from today. So we would ask that when the polling questions come up, if you're interested in responding, please do so fairly quickly. They'll bounce back off the screen, and then I'll report the results just a little bit later after we've captured them all. There are 3 parts to the first question. In which you'll have to scroll down, but in which county is your community located? What type of community do you live in? And is your community a 55 or better community? Sometimes that's referred as 55 plus. We don't say that at Castle. After I turned 55, they are all now 55 and better communities. So we'll let you answer those questions. I want to welcome back Michael and Jeffrey this afternoon. Before I let them introduce themselves, I do want to remind everyone that they are not intending to provide specific legal advice for your association. For those questions, you should reach out to your own legal counsel. However, we did want to have a discussion. This is a discussion this afternoon regarding the reopening of amenities and other issues we're facing as we continue to return to the new normal. We will comment today on what's going on in the area with respect to the new test results that we're seeing as well. So Jeff, let me ask you to introduce yourself and the firm, and then we'll go to Michael, and then we'll get back into business. So Jeff.
Thank you so much, and good morning to everybody, and thank you for attending. K. Bender Rembaum, we are 19 lawyers, 26 staff, 3 offices, Broward County, Palm Beach County, Tampa, Hillsborough area. All 19 lawyers are dedicated to Florida's community associations and representation of them. We represent about 1,200 or so, maybe a few more. Community associations as the numbers are growing. I author Rembaum's Association Roundup, which comes electronically to your inbox and has found a new home in the Florida Community Association Journal, which I'm very proud of. 9 of our lawyers are board certified experts in condominium and plan development law. That includes Michael Bender and myself. And with that, I'll turn it over to you, Mike.
Good afternoon, everybody. Thanks, Jeff. Thanks, Craig. Happy to be here. Thank you all for joining us this afternoon. We have some good info to share. I'll just quickly add, we do also have locations in Miami-Dade that are by appointment. As Jeff mentioned, our client base runs from north of Tampa all the way down to the Keys. So with that in mind, we also are opening up our education, and please do try to get onto as many education classes. In addition to COVID, there's still life is proceeding, and we're doing a lot of education on updating documents, guest restrictions, and fair housing issues, all those good things. So keep those. If you're interested, you can hit us at info@KBR Legal for that info. And Craig, let's get started on the good stuff.
Okay, guys, we have 6 things to cover on our agenda today. We're going to have a quick legislative update. Again, talk about emergency powers of the board and comment on what's going on with the DPBR and the state. And talk through the amenity reopening, review the things that we talked a little bit about in the last episode, and then have a little longer discussion on those topics. We're going to talk a lot more today about non-essential visitors and what associations our participants here are doing. little bit about liability and risk mitigation, and then what's next, and if we have time at the end, any questions and answers. So that's the package we have for the next 50 minutes. And let's first, before we get into it, on the current legislative environment, Nez, if you could show the results of our first question, please. So it looks like most of our participants are from the Tri-County area, which is what we expected, which is good because we're going to focus in on the Tri-County area. Can you scroll down to see what types of communities that we're living in? I see that 41% are in HOAs and 59% in condos and co-ops. And then how many 55 and better communities do we have? We have 36% are 55 and better, and the rest are regular folks, I guess is the best way to describe them. So a great mix of community types and of geography. So that's good news. On the legislative front, guys, good news is there's been no, we have not been subject to any new errors from the governor in the last 2 weeks. We're still under the state of emergency order set to expire on July 7th. And most of the state is in phase 2 of the Safe, Smart, step-by-step plan for recovery that the governor has authored. Of course, those exclude Palm Beach, Broward, and Miami-Dade County. So that's still a target that we're searching for in the Tri-County area. As a reminder to our webinar participants, it is the state of emergency order by the governor that triggered the emergency powers contained in the statute 718 and 720 that boards utilize, I guess 719 as well, that boards utilize to shut down the amenities and restrict access to their communities. There was one new order late yesterday in Palm Beach County. Jeff, is there anything in that new order in Palm Beach that changes the playing field for community associations?
Tangentially, it doesn't change anything in regard to tennis courts and swimming pools and basketball courts. It does, however, address private parks. And many of our associations have private park type areas. So I think we need to take this new order into account. It's Palm Beach County Executive Order 2020-011. It's the 11th executive order. If anybody wants to read it in its entirety, you're most welcome, but you'll find attachment 4 toward the back of that order. Public county and municipal parks, private parks, all may reopen subject to the CDC guidelines, including social distancing. However, the park playgrounds, play and exercise equipment still must remain closed. You can have a picnic pavilion for up to 10 people, and water fountains must be turned off. Congregating in groups of 10 is prohibited.
In groups greater than 10.
Congregating in groups of 10 or more is prohibited.
Perfect.
Yeah, that's what this order says.
So nothing really for us at this point that really provides any more guidance.
Well, it affects our tot lots and things like that, yeah. I think.
Fair enough. Guys, in addition to, of course, the governor's order, every county in the state and every local municipality has issued different guidelines, and we continue to advise our clients that you have to be mindful of the restrictions that impact your community, and continue to seek the guidance of your attorney and other professionals as you flesh out your reopening plan, because there are lots of nuances, some of which we're going to hit on. Our plan today will be to build on our discussion from last week regarding the reopening of amenities. Most of the comments will be applicable to all amenities and all community types. So let's move on. Emergency powers of the board. I previously stated that it was the executive order that triggered the emergency powers contained in the statutes that the boards utilized to shut down their amenities and restrict access. Last week, we touched on a communication from the DPBR weighing in on this issue of emergency powers. In reading through the questions raised by the participants today, there seems to still be some confusion on exactly what impact that new ruling from the DPBR has. Michael, can you give us a brief history on this issue and where we currently stand?
Sure, great. Basically, the confusion that started with people saying, hey, the state of emergency has been rescinded, and that's not the case. The Secretary of the DBPR, the governor's order, which was the state of emergency order that we, as I'll get to, many of us believe triggered the powers, that's extended to July 7th, 2020 as of today. The emergency order that was issued by the DBPR, that was intended to suspend the damage requirement that was set forth in the emergency powers section of 718, 719, and 720. And there was which was in response to early debate, which quite frankly that debate continues, whether the COVID-19 virus constituted damage such that it triggered the statutory emergency powers. So back in March, the DBPR issued an order that they believed to suspend the damage requirement. There's question as to whether that was outside of their authority to even do so, and their order extended to HOAs, which I believe clearly is outside their authority. But then, so there's a question as to whether that initial March order was necessary. It did help. It helped confirm what a lot of us believed. Effective June 1st, Secretary Bashir's rescinded that order, saying that the emergency powers, I guess, in their opinion, are no longer needed, or wasn't quite clear what the purpose of rescinding the order is or was. But regardless, still on June 1st and today, we have the language in each of the sections of the emergency powers in 718, 719, 720, which grants certain powers when there's a state of emergency declared, and that state of emergency still exists as well. So what we no longer have is the clarification from the DBPR about the emergency powers. And so just quickly, just wrapping up, remains our opinion, my opinion, Jeff's opinion, the opinion of many community association practitioners, not all, there is still a debate. And Secretary's position, I think, is contrary to what our opinion is, that the emergency powers described in 718, 719, and 720 do apply to this pandemic, upon which the current state of emergency is declared, regardless of the recent rescission of the DBPR emergency order. But as I pointed out last week, and I'll reiterate, this is an unprecedented state of events. And, if there are legal challenges that are brought, you can't really, we're all basically doing our best to interpret. And one thing I will add right now, just, it's the state of emergency that triggered the emergency powers. But it isn't and we'll get into this a little bit more, but it isn't the only basis upon which some of those powers can be can be put into place by the board. And we'll get into a little bit, because one of the verbiage in the statute does talk about these powers extending until such time that in order to protect the health, safety, welfare of the residents. And I think that's going to be, we'll piggyback off that a little bit later, but I think that's very relevant to understanding what we're talking about with these powers and the authority of the board, and what the obligations of these volunteer board members and these management teams are trying to do to protect the residents in the community.
Right. Jeff, anything to add there?
Sure. I think you had a question earlier about additional exposure and liability given the DBPR ruling as well.
Yeah.
And to piggyback off of what Michael said and the health, safety, welfare powers, you want to, before I get there though, you want to operate as close as possible to the procedural requirements for meeting notices and using technology, using Zoom platforms and things like that. But you still want to provide, when appropriate, your 48-hour or your 14-day meeting notices. You want to provide the members the opportunity to speak. The emergency powers are there for situations where you cannot comply with the procedural requirements, given the exigent circumstances that may be at hand in your association. So to the extent you can comply with meeting notice requirements and all the other procedural requirements in your documents, you should absolutely do so. If not, then the board can make that decision whether or not they want to use those emergency powers after consultation with the attorney for the association. If the emergency powers didn't exist at all, remember that we're all not-for-profit corporations at the end of the day. All condo associations, all homeowner, all cooperative associations are still subject to Chapter 617, the Not-for-Profit Act. And in that act, and it's also echoed in the Condominium Act, an officer, director, agent shall discharge his or her duties in good faith with the care of an ordinary, prudent person in a like position would exercise under similar circumstances and in a manner he or she reasonably believes to be in the interest of the association. So with that in mind, you have to do what's right to protect the people and to protect the property under the circumstances. So even if those powers didn't exist, we still have this health, safety, welfare clause sitting in the Not-for-Profit Act that does provide some guidance. And really, at the end of the day, what this is saying in a whole bunch of legal words, do what's right.
Right. Well, I think this debate will escalate as we get closer to July 7th and the possible lifting of the emergency order. It's going to come, I think it's going to come quickly. And I know in our next webinar, which is on July 2nd, hopefully we'll get some more clarity and detail on whether the order may or may not be lifted, and then really have a discussion on the implications for the associations if the state of emergency order is lifted. So go ahead.
Oh, I was just going to point out on the emergency order, you mentioned that it's expiring on July 7th, and we're all waiting with bated breath to see if it's going to be renewed or not. And while we were preparing for this seminar today, we found an emergency order 20-130 from the governor, where we still have emergency powers going back to Hurricane Michael, where it made landfall near Mexico Beach, Florida, and all those counties, or about 15 of them or so, are still under a state of emergency. So I do wonder what the governor is going to do.
So we all do. So we won't speculate at this point in time, but again, I think we'll have some more clarity as we approach the next webinar, and we can talk a little bit more about it. I want to bounce, guys, to the amenity reopening considerations, and I would like to Marinez to please post poll question number 2, and we want to get a feel for HOAs. This is if you live in an HOA, have you opened your pool, gym, and clubhouse? So only for those in an HOA, and then we'll come back and visit some of the other ones. The condos and co-ops later. And we want this data because we have a lot of questions around, kind of what is everybody else doing? I don't want to be out there on an island with the only closed pool and the only open clubhouse. So we're going to revisit those results in a little bit. So I want to move into a review of the regulations and a discussion on the reopening of amenities. But before I do, I don't think, Ness, I have to wait for this poll to end before I can post the second one, right? Okay, so we'll sit tight on the condo and HOA question while this one loads. But Jeff, I guess I'm going to start with Broward this time. So we'd like to get an update on where we are from a regulation standpoint in Broward, Palm Beach, and Miami-Dade, specifically as it relates to the reopening of pools, clubhouses, gyms, and maybe tennis courts if you know. So Michael, let's start in Broward. We know there have been no changes since our last update, but where are we in Broward with respect to the opening of pools, gyms, and clubhouses from a regulatory standpoint?
Sure. Again, I know that there have been no changes in the last 2 weeks. And so with regard to pools, pool decks, as well as the gyms and community rooms, the last requirement that was added was to extend the use of those community rooms, fitness centers, gyms, and pools and pool decks to family members if permitted by the board. And what I'm talking about is non-resident family members. Outside of that, the restrictions in Broward remain residents only. No guests are permitted other than family members, as the board may choose to allow by properly adopting a rule, which would also define what family members entails. The requirements for your limitation on capacity remain in place. The pool and pool decks in Broward County, you still have that either-or situation where you either remove all furnishings from the pool deck or you have supervised sufficient number of employees are designated to ensure compliance with the requirements, sanitize the pool chairs, railings. And guys who are listening, I am doing an abbreviated version. I encourage you to review the orders yourselves, contact your local council, your association council, to get more specifics on your do's and don'ts. But we have discussed these before, and so I'm not going to spend a lot of time going over them, but I do want to remind that with the gyms, again, the point is no guests outside of family members, non-resident family members, and the non-resident family members are not automatic. It's only if the board determines that they're going to extend that by properly adopted rule. Hot tubs, inside hot tubs, saunas, steam rooms, showers, those all remain closed. And they extended as far as, I guess that's what you want to talk about there. So as far as Brad, that's the situation.
Outstanding. Marinez, will you post now the same question about the pools, gyms, and clubhouses for co-ops before we share the results of the HOAs, if you don't mind? So if you're now living in a condo or a co-op, same questions, if you could answer those, that'd be great. And then Jeff, if I can skip over to you with respect to Palm Beach. Can you give us an update on what's going on?
Absolutely. We have some alarming statistics in Palm Beach County occurring right now. This morning's news reported 3 of our major hospitals, their intensive care units are completely full. We're down to somewhere, I've seen 2 different reports, 18% to 27% capacity remaining in the entire county in the ICUs, all related to COVID-19. We had 2,610 new cases in the state since yesterday, and the number I just saw, I haven't been able to flashback, but it might be over 3,000 cases. I just saw another news scroll by as we were talking. So with that in mind, I completely understand if, and especially in Palm Beach County, if boards want to keep their amenities closed a while longer, it certainly may make sense, pending what's happening in your condo or HOA. But short story is basketball courts may be open, tennis, racquetball, pickleball courts can be open, recreational buildings and gymnasiums may reopen, but subject to 50% capacity limitations and social distancing guidelines. Tennis courts, of course, are open, but the locker room and shower facilities still must remain closed. Restrooms must be cleaned and disinfected regularly throughout the day. It is the responsibility of staff and management to ensure compliance at the tennis court. Regarding the swimming pool, capacity is set to whatever social distancing in accordance with CDC guidelines results. Locker rooms and shower facilities must remain closed. The wording of the order is restrooms may remain open and be cleaned, which did create a little bit of confusion because when you have your commercial swimming pools, of course, you do have the added requirement of having a restroom. Pool deck seating and lounging must be restricted to ensure social distancing. And you must provide notice either electronically or by mail or by posting. I suggest to our clients that they cover this at least 2 different ways, one by posting and provide that notice to the members individually that all users of the pools abide by any and all social distancing guidelines, including but not limited to CDC guidelines, and most importantly, the users of the community pool bear responsibility of compliance and assume the full risk of utilizing the community pool. And that should help provide a little insulation, I think, when it comes to any type of proposed personal injury type litigation. The fact that Palm Beach County put that into the order that you're assuming the risk, I think only helps the situation. And we can talk more about that later. Now, the compliance can be accomplished by any reasonable means, including but not limited to periodic spot checks, video, other electronic monitoring, and or compliance hotlines to allow for reporting of violations that are thereafter promptly investigated. But remember, board members, you have the duty to make sure these orders are followed and carried out. You have to ensure compliance.
And Craig, I just want to add, and just so everyone's clear, that last line that Jeff just said, that applies across the board, Miami-Dade, Broward. Palm Beach's order regarding the pools in particular is very specific. Some of those guidelines, in my opinion, should be followed across the board. You should have proper signage in Broward, Miami-Dade. You definitely want to communicate with your insurance agents as well to ensure you're covering, you're ensuring that you're doing what your insurance carriers also want to see. And you definitely need to be ensuring that if you're opening, you are strictly following the guidelines and the requirements. And if you can't, don't open.
Good advice.
Good advice. Okay, guys, Marinez, if you could post, let's find out who's opening what. So if you could post the results of poll question number 2. So you live in an HOA, are your amenities opening? Let's see what we have here. So 48% of pools are open. More pools open than closed at this point in time. Your gym, still not very many gyms open, which is interesting. And I think that speaks to some of the physical restrictions of gyms and just how many people you can accommodate. And then is your clubhouse open? Again, very few HOAs with their clubhouses open at this point.
Good.
Can you post the answers for the co-ops and condos? Okay, let's see. If you live in a condo, is your pool open? Significantly more than on the HOA side, for sure. Basically 3 times the number of number of yeses than nos. Have you opened your gym? About equal, half and half for the gyms and condos. And then your common areas, common rooms still, not very many people are open at that point in time. So that gives you a feel, participants, for what your neighbors are doing with respect to amenities. I will say that I think it's important to note, and the guys have said it, you don't have to open your amenities at this point in time. There's no requirement that you do that. So you're well within your authority to continue to have them closed as long as, you know, you adopted the rules at a properly constituted meeting of the board, you've got legal advice. So we've got a lot of questions of, you know, do I have to? Well, you don't have to, and clearly a number of you are not at this point doing that. So
and Craig, I'd add, even after the emergency order expires, and we'll talk about this, I'm sure, in a couple of weeks, but even after, there's still good arguments to be made that the amenities do not have to reopen just because the emergency orders expire.
Yeah, especially if we start to think about what is going on in the communities these days. So
it's true. And again, and Craig, also to that point, which is really important to understand, we don't know what's going to happen with the state or the governor's order. Jeff pointed out earlier, we have Michael that's 2 years going. So I expect he'll likely extend that order. But even if he doesn't, the county orders aren't automatically dissolved. So as far as I understand.
Well, but they are tied to the executive,
right.
though.
So that's we'll have to see what goes. We'll have to. So you have to look at. There's a lot of different things we'll have to look at. But in addition to that, you still have your health safety concerns that the boards need to be addressing and considering. And Broward County even put in their order. Broward County's order specifically says, if you can't meet these guidelines, and I'm paraphrasing, don't open. And likewise, if you are open and you're not able to keep these things under control or people aren't cooperating, then close them again. I will say, though, those who've reported to me, on our clients who've reported to me, the people using the pools are doing so in a responsible manner, and that's important, and I think that helps keep things open.
Yeah, it's going to be an interesting time to, you know, to start to unravel everything when the governor rescinds his order, what happens with the county orders, what happens with all the other stuff. So that is a whole seminar, so a whole webinar. So we'll deal with that.
Looking forward to that one.
In a couple of weeks, yeah. Just before we skip down, Michael, quick update on Miami-Dade. I know they published a thesis on what's required to open your community pool/gym in Miami-Dade. So can you just give us a quick update on what's going on down there?
I can sure try. Thesis is a good choice of words. Yeah, for those who are listening from Miami-Dade, as Craig correctly points out, it is a thesis. Unlike in my opinion, unlike the Broward County and Palm Beach County orders that we've reviewed that seem to be a little bit more straightforward and specific to the community associations, Miami-Dade does have a booklet of 180 plus pages. And I recommend anyone from Miami-Dade that you get with your management team, get with your local association council for clarification on the do's and don'ts. The pools did, as of June 1st, pools were allowed to be open in Miami-Dade. As of June 8th, gyms were allowed to be opened. There are a lengthy pages worth of requirements, protocols that they've set out, some of which, and in their booklet, they bold protocols that are mandates, and then they're unbolded if they're recommendations. And they address workforce and visitor protections about, where your hand sanitizing stations need to be, disinfectant wipes around the pool deck. Try to establish a one-way flow into and out of the pool deck if there's a single entry point. Deep clean prior to opening, including the furniture, gate latches, handrails, life-saving equipment. There's a handful of requirements regarding what you need to do is, again, regarding chairs and lounges being 6 feet apart, the social distancing requirements, the training if you have employees that work the pool. And again, these guidelines are grouped to apply to community pools, pools at hotels, and also pools at residential communities, condominiums, etc. So there are some things that likely don't apply to association, condominium, or co-ops, or if there's some HOAs. But I'm as far as briefly goes, that's about as brief as I can get. But I will say this: it's a lot of information. I recommend that you guys definitely, before you consider opening up a pool or a fitness center down in Miami-Dade, that you communicate with your management team, get with your council, and make sure that you're doing what you need to be doing to best protect the association and your residents, most importantly. I mean, the numbers are rising, and Miami-Dade, as everybody knows, Miami-Dade's numbers are higher than everywhere else.
Yep.
Well, speaking, just so you know, state coronavirus cases skyrocketed. This just came in. by a record 3,207, and deaths climbed in one day by 18 to 43 for a total of 3,061 deaths.
It's scary. We're not done, I think, is the message.
We're not done.
Marinez, before we skip on, I just want to, for our 55 and better communities, give them some insight into whether their amenities are open. So can you post poll question number 4? And this is just if you live in a 55 plus community. So we can give you guys some guidance in terms of what your neighbors are doing. I think, guys, as as the communities flesh out their plan to reopen, we have the considerations of physical plant, of the demographics of your community, financial, whether you have the financial resources for the increased cleaning protocols, monitoring if that's what you're doing. So our kind of guidance is to seek the attorney's support and help as you relax the rules. Over communicate the plan in your community. Don't give in to the vocal minority. We have a lot of people saying, I have 3 people that are complaining about the pool. Well, you have, again, it's often the vocal minority, and we would suggest that if you don't think it's right, this is a decision you have to make as a board member. So if you don't think it's right, you're under no obligation to listen to that vocal minority who wants to jump the fence and swim in the pool. With respect to the pool, some best practices. If you do open, no pool furniture. It's easy. Everybody allows to have no pool furniture. People can bring their own. Blocks of time for pool use to control capacity. Clear signage, like the Palm Beach has made some great recommendations on signage that anybody can adopt. Document regular cleaning between blocked times. And also, I think you mentioned last week, Jeff and Michael, to document the cleaning
Yes.
that you're doing. If you're representing that you're cleaning after every hour and a half at the pool, document that it's done so that you always have that data to go back at.
Definitely.
With respect to the gym, consider just how many people can and will use the gym. We have huge communities that we manage with 1,000 people, and the gym can accommodate 25. Are you really going to go through that process of cleaning, opening, controlling the use for the 25 people or 100 people that can use the gym? And what we've seen from our survey is not all gyms are open. In fact, fewer than 25% are open in HOAs. Let's run back. Marinez, can we show the poll for our 55 and better communities just with respect to what's open? So if you live in a 55 and over community, half the people have opened their pool. Twice as many have opened than closed. Your gym, again, very few gyms open. Of the 67 people who responded that they had gyms, only 14 gyms are open, so that's not very many. And then finally,
I have to say, Craig, in opening pools in the 55 and older communities, and I learned this from Castle, because you guys have a wonderful reservation system that you've implemented in a few of the communities we represent. And I have found that the reservation system seems to be working really, really well.
Yeah, it does. That's a best practice that we're recommending. The whole opening it for an hour and a half, having a slot, reserving your spot, and then leaving, cleaning everything, and then having the next group come in.
And Craig, the only thing I want to add to that is these were what everything you just stated is excellent, and this is directed to those listeners outside of the Palm Beach, Broward, Miami-Dade. This applies to the entire state. So what Craig was just recommending, you're going to have local regulations that you obviously your own county orders, municipalities, and we're going to get into a little bit of that in a few minutes. Municipalities might have additional orders. Get with your local council and wherever you are in the state. But these guidelines, I think, are great guidelines for all communities, regardless of where you live in Florida.
Good. Thank you, Michael, for clarifying that. Guys, we got a lot of questions about masks. We're going to ask one additional poll question with respect to masks. So, Marinez, if you could post poll question number 6. Is your community, this is for all communities, is your community requiring masks to be worn in common areas? And Michael, let me start with you. While our participants are answering that, if you can comment on whether associations can mandate that masks be worn in common areas.
Sure, I'm happy to. And that's a question that we've been asked more and more. As you indicate, it's something that's becoming more of one of the biggest hot buttons. And quite frankly, I think if you watch any sort of these, whether it be through Facebook, which I happily try to avoid, or any of these video sites, you see these video encounters where people are screaming about having to wear a mask. And I personally don't understand it, but I have people I know and love who sometimes express these positions. But my opinion of many I speak with is, yeah, that is within the authority of the board to mandate, to say that in the common areas you need to be wearing a mask. And we'll get more into it. And I think I'll let Jeff talk a little bit more about it. I think the issue isn't, do you have the authority to mandate it? It's, if you do mandate it, it's the enforcement aspect that is challenging. But I do believe, yes, you have the authority to mandate masks be worn for all the reasons we've already expressed. And I want to point out something that came to our attention this morning. Our colleague Lisa McGill brought it to our attention this morning. That the city of Hallandale Beach, and I haven't seen the actual order, but the city of Hallandale Beach, I understand, has agreed to an order that says, and I'm reading this off of a Facebook post, but due to the number of COVID-19 cases increasing and the lack of compliance with face masks, particularly in condominiums, our city, meaning City of Hallandale Beach, has declared masks are mandatory in all common areas within buildings. This is not an issue of rights, it's for everyone's protection. And that is the quote from the post. And I don't know if the person wants me to acknowledge who posted, so I won't. But I agree with them that it is not an issue of right, it's for everyone's protections. It's not, in my opinion, not a significant burden to ask when you're in the common areas, if you're asking to wear a mask, that you have a mask on. Whether they mandate it or whether it's just something that everyone is urged to do.
Jeff, I'm going to ask you to talk about, the enforcement of that, the rule.
Sure.
But before I do that, Marinez, can you show the results of whether you're, if you live in an HOA, whether you're requiring masks? So a lot of no's. If you're in a co-op, a lot of more no's than yeses, whether you're in a co-op 55 and over or HOA community. Actually, just scroll down a little bit on the no's. Yeah, and I think it speaks a little bit to the practicality of enforcing that. So, Jeff, you and I talked about this yesterday. So the associations have
why not?
to enforce rules, but what are your thoughts on enforcing mask rules?
Sure. Before I answer that, if you live in a condo, I can understand the HOAs certainly not adopting a mask rule unless you're in the clubhouse or something like that. But in the condominium form of living, you're on top of each other, literally. In the elevator, some towers are 50 stories high. You're in that elevator for a long time. You've got a lot of opportunity for exchange between sneezes and breathing and coughing and people talking loud. Why not craft the rule and have it, even if enforceability, which we're about to talk about, is an issue? If you want to have any hope of enforceability whatsoever, you have to follow all of the statutory steps in regard to rule adoption. If you're in a courtroom and you're trying to justify a fine to somebody for $99, $100 because they didn't wear their mask, right? That's what we're talking about. You need to have the board properly adopt the rule. Then that rule must be communicated to the entire membership along with the date that rule is going to begin. Also, if you live in an HOA, a lot of HOAs are still not compliant with this, but the Florida legislature, in its infinite wisdom, amended a term inside Chapter 720. They amended the term governing documents to include rules and regulations. It always included the declaration, articles, bylaws, but now the term governing documents includes rule and regulations. Well, you keep reading Chapter 720 and you find out that and that's a defined term, governing documents, all the governing documents must be recorded. So if you don't have your rules and regulations recorded yet and you live in the public records of the county, then you absolutely want to discuss that with the association's attorney and find a way to make sure your HOA rules get recorded, because you don't want to provide an easy out. That would be an easy defense, I think, for someone to raise in a litigation setting. Hey, the rules weren't recorded. It says so right here, Judge. They had to be recorded. So watch out for that. So the fact that the rule itself may or may not be enforceable, why not err on the side of caution? Adopt the rule. You're always going to have that group that's going to try to thumb its nose and be the vocal minority, et cetera, et cetera. But why not err on the side of caution?
Michael, I think I agree, and I think I kind of adopt your strategy, which is it's just the right thing to do.
Well, and Craig, and I guess what I'm going to say to everyone listening, and for anyone listening, if you want to share it with others, and again, this isn't a legal opinion, it's just a piece based on the information we've been receiving and the conversations I've had, is whether you, and I recognize that the numbers are actually that they haven't mandated masks. I guess I'm not surprised at the results, but I just suggest, even if you don't have a mandate to wear the mask, especially like Jeff mentioned, in a closed setting, like in the condominium cooperative where you're in closed quarters, consider it a selfless act. Consider it something that you're doing for to benefit others, because hopefully nobody's has if you're wearing a mask, it's to protect others, not yourself. And so protect others. Let's all do our share.
Good stuff. Guys, we could talk about pools and tennis and bocce all afternoon, but I wanted to get on to non-essential visitors and just kind of get a feel for what communities are doing with respect to the rules they adopted. Most associations adopted rules limiting access to the community, especially limiting access to non-essential visitors, which were defined kind of as family, friends, realtors, contractors, housekeepers. From our participants, I'd like to ask you about what you're doing in your communities with respect to non-essential visitors. So, Marinez, can you post poll question number 5? To what extent are you allowing guests and non-essential visitors? This is a complicated polling question. You have to read down, check some boxes, but we'll go on. And I think I've seen a lot of emails, or questions chatted in regarding this issue. So before we get to the results, Jeff, what are you advising your clients right now about relaxing these rules?
With the increase in the COVID infections taking place, I certainly stand by any board that's making a decision to keep those restrictions in place. I do find that some of the condominiums we represent in Palm Beach County that had full restriction on guests are finding mechanisms for realtors to be able to at least get into a unit and do virtual showings and the like. Some of the condominiums are allowing the prospective purchasers to come through so long as they're compliant with CDC guidelines and masks and things like that.
Michael, anything to add from your standpoint?
Only, again, I think what Jeff is expressing, I think, and I've seen it with some of our clients in Palm Beach, but and as well as in Broward, Miami-Dade, and likely throughout the state. As far as, I guess, as far as when you're asking what are we advising them regarding relaxing the rules, it's a business decision as everything else is, and to take into account, it's the same discussion we've addressed. It's the same premise that we've just addressed with this whole pandemic situation. It's just and the whole thing just struck me as how crazy this all is, and I think we're all, all you board members, you volunteer board members, you took on the task of doing this job, and presumably many of you were on the board before this COVID hit, and now you're dealing with this situation. Craig, your management team and managers, this is something, first impression for everybody there. So we all just got to try to work together, and try to get ourselves through this, and we will get through. We will come out on the other side. But it's just a matter of everybody can cooperate. It will make the stressful times and these bizarro times easier. And in that regard, with relaxing the rules, I guess you just need to be cognizant of what you're doing, how you're doing it. I think to the point we made earlier, I have a few communities where there's 2 or 3 people pressuring. Some have sent threatening letters from lawyers. And I wouldn't kowtow automatically to that. I think you need to engage in discussions and figure out exactly what, when, where, how. And there are ways to relax some, but I would say that you also have a reasonable basis, especially with the data, to not necessarily do so at this point.
Agreed.
And I want to just one quick one. I just had someone send me a quick text about the conversation, and I haven't confirmed this, but I trust the source, that Monroe County just made it mandatory to wear a mask anywhere under a roof. So that has to be confirmed, but that's down in Monroe. So
wow.
It's going to be interesting. We had kind of a quiet 2 weeks. Now we're starting to see some results about what's going on in testing and capacity of hospitals, and maybe we're going to see a ramp up again of the executive orders and different rules and regulations. Guys, let's look to our poll. Can you post the results of the poll, Ness, please, about the allowing of guests? I just want to run through these guys because I'm a little surprised. They're a little higher than I would have thought.
yeah.
If you live in an HOA, are you allowing 69% of those polled said they're allowing contractors.
That makes sense in the HOA
The
context.
HOA, I'm surprised the condos are even higher.
Yeah, let's go down to the condos. The HOAs, so about 70% of people are letting non-essential guests into the community in HOAs. For condos, 75% are allowing contractors, which is the highest amount, but still the majority are allowing realtors and family as well. So I'm a little surprised by those results.
All right, if we're going to have that many people in condos, then I want to advocate that really they should be using masks and have the requirement for masks for these people
Right.
coming in and out of the building.
And that's obviously not part of the question, but I do believe that is where at least the experience that I've had in communicating with clients is if they're relaxing the rules, they're allowing limited numbers, they're requiring them to be masked, some are requiring them to be gloved, but everybody's going in and out of the elevators. And I do think there's that's part of the reasonable conversations that you can work on, limiting times, scheduling times, same thing you do with the pool and other things. So there are ways to do it.
But however, if I do understand correctly, there is no obligation, specific obligation to allow non-essential guests into your community at this point in time. Is that correct?
That's one position to take.
That's an acceptable position. A lot of people are allowing them in.
An acceptable position under the circumstances, Craig. If you want to continue to prohibit contractors, realtors, and non-family members from coming into the building, given the data of COVID-19, the increase in cases, the increase in deaths, it certainly makes sense, either health, safety, welfare, or using emergency powers to continue to do so at this time. And then you'll deal with those one-off situations when they occur.
Well, and again, and Craig, and this ties into what we're heading toward. It is about liability and risk mitigation. And so if you make the decision as a board, you have a reasonable basis to do so. You get guidance from your legal counsel, you get guidance from your management team, your business advisors, other experts perhaps, and you make a decision to keep things closed. Someone decides that you're breaching your fiduciary duty. Well, the likelihood is that you're going to have coverage for that. Communicate with your insurance team, get with your insurance agents, get with your and get that type of guidance as to what coverages you have and what will or won't be covered. The flip side is you allow the opening and now people are coming in and someone now brings a claim, hey, everything was fine until you opened up the doors and now we have been exposed and I have COVID or a friend has COVID or whatever the situation is. Do you have coverage for those types of claims? I'm not saying they can prove it. Proving the case, the causation, proving negligence, that's a whole different story. We're not getting into that discussion right now. But whether you have the coverage to start defend such a claim, and that's kind of what you're weighing. And documenting what you're doing and enforcing. If you're going to allow the contractors come in with masks only and only in groups of 2, make sure that you enforce that strictly and that the residents understand this is what we're doing and it's a limited basis. And if it's abused, we're going back to a ban.
Hey, Craig, next time we do this, maybe we can have another question and poll for those allowing in the contractors, realtors, family. What are the requirements for those people? Are they requiring masks?
Yeah, I think it's a good idea. And our experience has been those associations that we manage that are doing this have very specific rules with respect to these contractors and family and contractors and non-essential guests that are visiting the community. Guys, Michael, you started to talk about liability and risk mitigation. Our best advice continues to be, it's easy for, to change these rules. It's actually not easy to change the rules. You need to change them at a meeting of the board that's properly constituted, with the guidance of your attorney. I'm not sure that we're seeing all of that happening all of the time. So that is kind of our best advice is make sure you're not off, doing this on some subset of the board of directors deciding they're going to change the rules with respect to non-essential guests. Guys, I want to talk about, now let's talk about risk mitigation. There's been some discussion about owners signing waivers when they when they use the pool, they want to use the gym. Does having a resident sign a waiver or hold harmless really provide any help to reduce the potential liability of the association?
Maybe. It might. In a courtroom setting, the Florida courts disdain that type of self-serving waiver, but it never hurts to try is sort of the adage. It's a balancing test between a member who says, hey, I have a right to use this amenity anyway, and absent clear authority in the governing documents. I do have some clients, large HOAs, where in the governing documents, it gives the authority to the board to require a waiver in the first place. Before using the amenities, you have to sign the association's waiver. That's clearly disclosed. And I think that waiver stands a much better presumption of enforceability later if there's a problem, as compared against an association that doesn't have that. But why not try? Why not have something to try to protect the association given everything that is going on? We simply, as lawyers, can't predict whether or not that's going to be whether it would stand up upon legal challenge. Mike?
Would that be similar guidance on signage? No downside to putting up signage like Palm
Well,
Beach?
Palm Beach County, you're putting up the signage regardless.
No, I would say no, definitely no downside. I think only upside. You definitely want to have signage there. I think you want to have it in your pools, your gyms, everywhere. And again, I'll reiterate, you want to make sure that the language is something that your carriers want to see. If Palm Beach gave specific language, but I think you want to, there's that type of language seems to me to apply. So for sure you have signage. With regard to having residents sign these waivers, home harmless, again, I think it's maybe acts more of a deterrent than it certainly doesn't insulate. Can it lessen? Perhaps. Can you mandate that a resident sign a waiver before using a common amenity? We discussed whether that's something that's subject to challenge. I think that the law does allow for reasonable restrictions, and would that be considered reasonable to have them sign a waiver? I don't know that a resident's really going to be that opposed to signing a waiver before using the gym anyway, because they probably sometimes you have to sign one of those anyway, just using the equipment.
And if the member does get up, hey Mike, if the member does get upset and decides to file a lawsuit, in the meantime they're not using the amenity because we said you can't use it unless you sign the waiver. And by the time the case is heard in court, it's going to be 1.5 years from now. So you want to use the pool, you want to get wet, you better sign.
There's all those issues, like I said. So you have your legal issues, you have your practical, and they don't always jive.
Right. I want to jump to insurance, which is a key part of most associations' risk mitigation strategy, risk management strategy. There seems to be a general consensus that claims for damages related to COVID-19 won't be covered by virtue of exclusions in most policies. Jeff, your thoughts on that and what an association is going to do? And I do want to follow that up with a quick comment. Michael, you talked a little bit about defense fund insurance last week, and I wanted you to just comment on that again if you could. Legal defense insurance, excuse me.
I can answer both.
Okay.
The understanding that we have as legal professionals versus your insurance experts, although we have a lot of experience with insurance, and what we've learned throughout these last 3 months in having some excellent insurance professionals who've done some of these programs with us or communicated with us, is that the personal injury or emotional distress type damages people might claim due to the COVID spread are going to be not covered by the directors and officers policy. So you're looking to the general liability policy, and you need to check. Most policies, in my understanding, they were excluded. Many, almost all, I thought excluded initially. I have since come to here, I haven't confirmed this, that there actually are policies that may offer, general liability policies that may offer some coverage. It's why I've repeated, you guys have heard me say this every couple of weeks and every time I speak, is that you need to communicate with your insurance agent. You need to get in writing confirmation as to what policies you have in place, what coverages you have in place, what policies or coverages you don't have, what exclusions exist, and what's available to you to blanket those exclusions to give you that blanket coverage. And so get with them and get that. And I said, have meetings, have Zoom meetings with your agents. If you haven't already, do it regularly. Get this kind of guidance. They're the people who know what's going on. They can best help you. With regard to legal defense, that's the gap coverage. And if you don't have coverage under directors and officers, and if you don't have you have exclusions on your general liability, then you are sitting there uninsured when it comes to a potential COVID claim. A legal defense policy, again, from my explanation of it, is that it's a policy that will offer you coverage of legal defense costs. If you have no other coverage, it's a gap coverage. I've been told that it's coverage that doesn't have a deductible. That's something you need to confirm. I've been told that that's a coverage that if you have it, The carrier is going to select your attorneys. You don't have a choice who that attorney is, but that what it is your attorney's fees are covered. It does not cover any damage claim that is a judgment against you. It doesn't cover any cost of settlement, although that would ultimately be a business discussion you'd have with your carrier, I would imagine. It might be in the interest of the legal defense coverage carrier to throw a few bucks as opposed to paying more in fees, but I don't even know if that's an option under a legal defense policy. Get that information and guidance. But that's called gap coverage. It's when you have no other coverage for a particular type of claim. Legal defense coverage will provide you coverage for the attorney's fees you'd otherwise have to pay out of your pocket.
And you get what you pay for.
Well, that's the point I was going to make, Jeff. I go in eyes wide open with respect to these policies. Like any other insurance policies, there's a whole bunch of exclusions. There's a whole bunch of conditions that have to be met for them to trigger the coverage. So don't go in without, just obviously discussing with your agent, but go in eyes wide open. There are lots of exceptions to when that could apply as well.
And I reiterate, when speaking with your agent, getting confirmation from your carriers, ask for it in writing. Get document in writing what coverage there. So if down the road they claim it's not covered, you have a written instruction from them that it was to be covered.
Yeah. Guys, we're winding down. I just wanted to touch on what's next. On July 2nd will be our next webinar, episode 6. Hopefully by that time there'll be some more clarity on what the governor will be planning to do with the existing emergency order. And then we're going to talk a lot about the impact that lifting that order will have on our communities, what we can do to protect ourselves from an association standpoint. We'll also review changes maybe that an association can make to their documents so they don't have to rely on governor's state of emergency declaration.
Yes.
Able to
We
exercise.
started doing that, Craig, with some of our clients that
Yeah.
have requested it.
That's a big topic for that. That's definitely something people want to be proactive with. Get with counsel and discuss about updating documents. Whether
And I also I want to borrow from the Tiffany Plaza progeny about boards' emergency powers, and when boards do things that aren't necessarily authorized, like when a board passes a special assessment without a vote of the members, and how could that ever happen, and things like that. And I think we can borrow from that body of case law and apply it to our COVID-19 situation as well. We'll talk about that next time.
Yeah, I like that. I think, guys, we also want to touch on the HEROES Act. There was some inquiry as to what's going on there, and I think maybe,
I can answer that one real quick if you'd like.
Is it dead?
The HEROES Act is something up in D.C. It's federal legislation, and the impact the HEROES Act would have, if passed, the potential negative impact it would have was the inability to collect a debt. And it was not exempting community associations from it. It did go through the House, but it is not going to pass the Senate. President Trump's already said if it did, he'd veto it. But I don't believe it has any shot of going through the Senate. I was on calls with legislative aides for Senator Scott and Senator Rubio through CAI, Community Association Institute, and the Florida Legislative Alliance, and we had discussions with both of those senators' teams in urging them to not support, not co-sponsor, or if it is at any chance of going through, to make sure there is a carve-out for community associations, since community associations have only one financial lifeline, and that is the assessment situation. So I don't believe that bill is got a chance to go through in DC, certainly in its current form.
Good. Well, that's good news, I think, for all associations, certainly all the treasurers that are listening today would be happy about that. Guys, I want to thank you again for your time. Michael, Jeff, really appreciate it. Everybody who checked in today, thank you very much for listening. Michael, any last words?
I'm going to also thank you very much, Craig. Thanks, everybody, Castle, for putting these together. Thank you all for attending. Hopefully, everybody got a little bit more information. Again, I just wish everybody the best. Stay safe, stay smart, stay selfless. Let's all work together to get us through this. And from a legal standpoint, if you need us, you know where to find us.
Jeff, anything from your end?
Wear a mask when you're in a public area. Be considerate of your neighbors. Do the best under the circumstances. And remember, you have a community of 1,000 people, 500 people. You have 30 or 40 people yelling and screaming. I refer to them as the vocal minority. Do what's right. Stick to your guns.
Yeah, great. I think that's great guidance. And I'll take the opportunity to thank again everybody for joining us this afternoon. Thank you for what you do. And we'll look forward to speaking with you in a couple of weeks. So take care, everyone.
Thanks.
You well.
Bye-bye.